What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Wednesday, July 9th. A little late getting this out, but I just got a new filing in the Kouri Richins case. We're going to break that down real quick. A very interesting filing. This is an objection and motion to quash a subpoena and also sanctions and a request for a hearing. This filing is from Gregory Skordas. He is the victim's advocate and the spokesperson for the Eric Richins family. Kouri's defense team is asking for 3 years of communications, and Mr. Skordas is fighting this under several premises. Number one is communication with the Richins family is protected under Utah's victim advocacy laws for privacy and confidentiality. Number two, he has at least 50 other clients that have been tried in Summit County, and that subpoena would cover all those 50 clients which are unrelated to Kouri Richins. Number three, his other clients and the Richins all have an expectation of privacy and confidentiality under Utah law. This is a pretty bold request, but let's break it down. Comes now, Gregory Skordas, spokesperson for the Eric Richins family, files this motion to quash subpoena under Utah Rule of Civil Procedure 45E and Utah Rule of Criminal Procedure 14 and moves this court to, number one, quash in part the subpoena issued by defense counsel Catherine Nestor, attorney for Kouri Richins, dated June 23, 2025. Number two, impose sanctions and attorney fees pursuant to Utah Rules of Civil Procedure 45E1. Number three, refer defense counsel issuing the subpoena to the Utah Office of Professional Conduct for ethical violations if appropriate. And number four, award any other relief deemed just and proper. Mr. Skordas first responds to each numbered request in the subpoena as follows. By the way, the subpoena is not available publicly at this time. Number one, Mr. Skordas objects to disclosing all emails, letters, text messages, personal or professional correspondence between any employee of the Summit County Attorney's Office requested in 1A of the subpoena. The basis for the objections to this request are more fully set forth below. Number two, Mr. Skordas has never communicated with Detective Jamie Woody and does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1B of this subpoena. Number three, Mr. Skordas has never communicated with Detective Jeff O'Driscoll and does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1C of this subpoena. Number four, Mr. Skordas has never communicated with Eric Root and does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1D of this subpoena. Eric Root is another detective on this case. Number five, Mr. Skordas has not communicated with any employee of the Summit County Sheriff's Office and does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1E of the subpoena. Mr. Skordas objects to disclosing all emails, letters, text messages, personal or professional correspondence with any member of the Eric Richins family requested in 1F of the subpoena. The basis for these objections are more fully set forth below. Number seven, Mr. Skordas does not have retainer agreements or engagement letters with any of the Eric Richins family or the Eric Richins Living Trust to provide as requested in 2 of the subpoena. Number eight, Mr. Skordas does not have any checks made payable by the Eric Richins family or the Eric Richins Living Trust as requested in 3 of the subpoena. Mr. Skordas' work for the Richins family is pro bono. The next section, motion to quash and for sanctions and attorney fees. Introduction. This motion seeks to quash a subpoena issued by defense counsel that 1. Demands production of privileged communications between victim's advocate and the victim. 2. Demands production of privileged communications between Mr. Skordas and the Summit County Attorney's Office, completely unrelated and irrelevant to the issuing defense attorney's case. And 3. Unduly burdens Mr. Skordas by requiring him to parse through identify and produce 3 years and 3 months worth of communications with the Summit County Attorney's Office dating back to March 3rd, 2022, when almost none of these communications have anything to do or any relevance to the issuing defense attorney's case. This subpoena for extensive, irrelevant, and privileged communications was issued 1. In direct violation of court rules and ethical obligations. 2. Without any good faith legal basis. 3. For an improper purpose, apparently to burden Mr. Skordas unnecessarily by asking him to produce 3 years and 3 months worth of communications with the Summit County Attorney's Office, the vast majority of which have nothing to do with the issuing attorney's representation of Kouri Richins and are also protected by the attorney-client communications privilege. And 4. To harass the victim's family by requesting privileged communications between the Richins family and Mr. Skordas. The subpoena must be quashed and sanctions imposed under Utah Rule of Civil Procedure 45 to deter the use of defense attorney subpoenas to compel production of clearly privileged communications without any legal justification, to deter the use of subpoenas that ask for irrelevant communications, and deter the use of subpoenas that overly burden the subpoenaed party, and to protect the integrity of the process by which defense attorneys issue subpoenas. The next section is the factual background. Number 1. On June 23, 2025, Catherine Nestor, defense counsel for Kouri Richins, served a subpoena upon Gregory Skordas, victim's advocate for the Richins family. Most of the communications requested by the subpoena are either subject to the attorney-client communications privilege under Utah Rules of Evidence 504 and or the victim advocate privilege under Utah Rules of Evidence 512 and Utah Code. Number 3. The subpoena requested all of Gregory Skordas's communications with the Summit County Attorney's Office dating back to March 3rd, 2022 without any kind of limitation to requesting only communications relevant to the issuing attorney's current representation of Kouri Richins. The issuing attorney knew or should have known that she was engaged in an overly broad subpoena request because Mr. Skordas's communications with the Summit County Attorney's Office would necessarily include dozens of communications regarding cases handled by Mr. Skordas that are completely irrelevant to the issuing attorney's current representation of Kouri Richins. 4. No motion, court review, or attempt to confer occurred before this invasive subpoena was served. Number 5. The subpoena imposes an undue burden on Gregory Skordas to produce all of his communications with the Summit County Attorney's Office in the last 3 years and 3 months. Number 6. The subpoena additionally seeks to expose confidential, privileged relationships and communications between Mr. Skordas as a victim attorney advocate and the victim's family without any apparent basis for requesting these communications or any attempt to limit the requested communications to those relevant to the issuing attorney's current representation of Kouri Richins. There has been no attempt by the issuing attorney to explain why privileged information should be produced or to have the court make a determination on any privilege claims before simply demanding production of privileged communications that the issuing attorney should have known were privileged. Number 7. The subpoena imposes an undue burden on Mr. Skordas by commanding him to produce all of his communications with the Summit County Attorney's Office over the last 3 years and 3 months, the vast majority of which are both subject to the attorney-client communications privilege and relate to other cases handled by Mr. Skordas in Summit County that are completely unrelated to and irrelevant to the issuing attorney's current representation of Kouri Richins. Mr. Skordas estimates that he has handled a rough approximation of over 50 cases since March 3rd, 2022, requiring extensive communication with the Summit County Attorney's Office. It would create an undue burden on Mr. Skordas to be required to parse and sort through hundreds of communications with the Summit County Attorney's Office that are completely irrelevant to the issuing attorney's representation of Kouri Richins. The issuing attorney should have known that Mr. Skordas has had extensive communication during the last 3 years with the county attorney's office that have nothing to do with her case, but did not make any attempt to limit this response. Next section, legal standards and argument governing Mr. Skordas's request for sanctions and attorney fees. Violation of Utah Rule of Criminal Procedure 14. Rule 14 governs the issuance of subpoenas in criminal cases. A criminal subpoena may command the person to whom it is directed to appear and testify, or to produce in court, or to allow inspection of records, papers, or other objects. The court may quash or modify the subpoena if compliance would be unreasonable. Rule 14 thus adds a reasonableness determination for whether the court may quash a subpoena. Idaho Rule 14A2's limitation allows the court to quash or modify a subpoena if compliance would be unreasonable. They cite State versus Lopez. Lopez does not apply blanket criteria in determining the reasonableness standard, but rather that the reasonableness of a subpoena should be determined under the specific circumstances under which the particular subpoena was issued. The subpoena in this case is unreasonable under the circumstances. The bulk of the requested communications, specifically the request for Mr. Skordas's communications with the attorney's office dating back to March 3rd, 2022, have nothing to do with and are completely irrelevant to the issuing attorney's current case. The issuing attorney knew or should have known that the bulk of her requested communications were completely irrelevant to her representation of Kouri Richins. The subpoena is thus unreasonable on that basis alone under Rule 14 and should be quashed. Defense counsel's subpoena is also unreasonable under the circumstances because it targets privileged victim communications and confidential relationships, which are explicitly protected by Utah Rules of Evidence 504 pertaining to attorney-client communications privilege. They also cite victim communication privilege law. Furthermore, crime victims have a right to be treated with fairness, respect, and dignity, and to be free from harassment and abuse throughout the criminal process. The subpoena in this case is unreasonable. It requests extensive privileged communications between Mr. Skordas and the victim's family. The issuing defense attorney knew or should have known that her subpoena targeted information protected by the attorney-client communications under Utah Rules of Evidence 504, Utah Code, and also Utah Rules of Evidence 512, which makes it even more unreasonable and requires that the subpoena be quashed. Rule 17 states that the provisions of Rule 45, Utah Rules of Criminal Procedure, will govern the content, issuance, objections to, and service of subpoenas to the extent those provisions are consistent with the Utah Rules of Criminal Procedure. This requires that the subpoena be subject to further analysis for its compliance with Utah Rules of Civil Procedure 45, which has been incorporated into Rule 17 by reference. Part B, violations of Utah Rules of Criminal Procedure 45 and mandatory sanctions. An attorney admitted to practice in Utah may issue and sign a subpoena as an officer of the court. The subpoena power is one of the most significant and powerful privileges granted to Utah attorneys. The extensive power to compel anyone in the state of Utah to give testimony and produce documents and communications comes with an equally extensive responsibility to not abuse that power. Rule 45E1 mandates quashing subpoenas that 1. Require disclosure of privileged matter, or 2. Impose an undue burden on the subpoenaed party. The issuing defense attorney served a subpoena on Mr. Skordas that both requires the disclosure of privileged communications and imposes an undue burden on Mr. Skordas. The issuing attorney has requested from Mr. Skordas, among other things, quote, any and all emails, letters, text messages, personal or professional correspondence dated on or after March 3rd, 2022, between you and any employee of the Summit County Attorney's Office, end quote. Mr. Skordas has a large active caseload, including many cases in the last 3 years and 3 months in which he is engaged in privileged communications with the attorney's office regarding other clients represented by Mr. Scortis in Summit County. Mr. Scortis roughly estimates that he has handled over 50 cases in Summit County, requiring hundreds of communications with the attorney's office during the period dating back to March 3rd, 2022. Complying with this request would not only be unduly burdensome, Mr. Scortis would be required to scour his extensive communications with the attorney's office and produce all of his communications with the Summit County Attorney's Office occurring on or after March 3rd, 2022. The vast majority of these communications between Mr. Scortis and the attorney's office relate to completely separate criminal matters and cannot possibly have anything to do or have any relevant information regarding the issuing defense attorney's pending representation of Kouri Richins. It's not possible that the issuing attorney was not aware that this request would cause Mr. Scortis to comb through approximately the last 3 years and 3 months of extensive communications with the Summit County Attorney's Office, and would result in the production of irrelevant and privileged communications that are completely irrelevant to the issuing attorney's pending representation of Kouri Richins. The issuing attorney did not even try to limit the scope of the subpoena to only relevant, non-privileged communications. The issuing attorney did not state any reason for why the requested communications were in any way related to the defense of her client. The issuing attorney did not try to limit in any way the scope of requested communications to communications only relevant to the issuing attorney's defense of her client in the pending criminal case. Rule 45E3 further provides that the issuing attorney has a duty to avoid burdening subpoenaed parties by not 1. Issuing subpoenas targeting communications that are privileged, and 2. Issuing subpoenas that impose an undue hardship on the subpoenaed party. The attorney in this case has issued a subpoena that violates each of these prohibitions. Rule 45 provides that the party or attorney responsible for issuing all subpoenas shall take reasonable steps to avoid imposing an undue burden or expense on the person subject to the subpoena. The court shall enforce this duty and impose upon the party or attorney in breach of this duty an appropriate sanction, which may include but is not limited to lost earnings and a reasonable attorney fee. If an issuing attorney fails to do so, the court shall impose an appropriate sanction, which may include but is not limited to lost earnings and reasonable attorney fees. This is not discretionary. The language in Rule 45 requiring the court to impose sanctions is mandatory. The operative word is shall. Mr. Scortis has now had to spend considerable resources in objecting to this overly burdensome subpoena. Mr. Scortis would not have to spend resources objecting to this subpoena if the issuing attorney had limited her request to communications relevant to her case and not sought privileged communications without any kind of reason or statement for why the communications might not be privileged. The issuing attorney has thus failed to take any reasonable steps to avoid imposing an undue burden and expense on Mr. Scortis and is therefore subject to mandatory sanctions under Rule 45. As already stated, the issuing attorney did not make any attempt to limit the requested communications to those relevant to her case despite ample opportunity to do so. The issuing attorney did not in any way need to request all of Mr. Scortis' communications with the Summit County Attorney's Office dating back to March 3rd, 2022. The issuing attorney could have simply requested only the communications between Mr. Scortis and the attorney's office related to her case, but she did not do that. The issuing attorney could have requested the privileged information requested be subject to review by the court to determine whether any privilege applies before compelling production, but she did not do so. Because the issuing attorney took no reasonable steps or care to avoid imposing an undue burden on Mr. Scortis before serving a subpoena that was overly burdensome and which required Mr. Scortis to expend legal resources To object to the improperly issued subpoena, the issuing attorney must be sanctioned as deemed appropriate by this court. Mr. Skordas has submitted a request for a hearing with this motion to determine its merits and award sanctions and attorney fees. Commiserate with the legal resources that Mr. Skordas has been required to employ to object to this purposely improperly issued subpoena. C. Ethical duties. Defense counsel's conduct violates the rules of professional responsibility, namely 1. Rule 3.4, disobeying procedural rules. And number 2, Rule 4.4a, using means that burden third persons, and Rule 8.4d, undermining the administration of justice. The actions of the issuing attorney described in detail above have violated these rules of professional responsibility. And finishing up, a prayer for relief. It is requested this court, number 1, quash the subpoena in part, specifically request 1A, requesting all of Mr. Skordas' communications with the attorney's office, and request 1F, requesting all of Mr. Skordas' communications with any member of Eric Richins' family. 2, award sanctions pursuant to Utah Rules of Civil Procedure 45E1, including reasonable attorney fees. Number 3, refer defense counsel to the Utah Office of Professional Conduct if appropriate. And 4, grant any other relief deemed just and proper. There's also a request for a hearing. Mr. Skordas requests a hearing on this motion when it's ready for decision and to determine sanctions under Rule 45D and the amount of attorney fees incurred as a result of Gregory Skordas needing to respond to the intentional issue of an overly burdensome subpoena on him by the issuing attorney, Catherine Nestor, and to grant any other relief deemed just and proper. So that is the new filing. This was filed yesterday by Mr. Skordas, July 8th, 2025. And just a reminder, previously the defense fought tooth and nail from the state getting communications between Kouri and her former attorney, Sky Lazaro. Now, the state argued with that because she was telling her mom what she and Sky had talked about. She had waived attorney-client privilege. But in the end, the judge said no, and his reason was the sanctity of attorney-client privilege. I don't think I've personally ever seen a case where the defense is asking for private communications between the victim's advocate and the families. Again, the filing by the defense is not public, but if it is made public, I will definitely do an episode on that. So that's the latest. It'll be interesting to see what the judge does. Pretty sure he's not going to allow her attorney to have private communications between Eric's family and the victim's advocate. All right, guys, that's it for today. Hope you have a good rest of your evening, and we will see you soon.